consequences of not having a will in particular, I know what you're getting at here.
I hoped you did.
There aren't really any cost consequences to not having a will in particular. The one cost that could come up, generally when I prepare wills for my clients, I do waive the bond. And the bond could be significant. The bond is determined by the amount of the estate. So it could be, for this particular gentleman, since he didn't have a will, there was no clause stating that he waived the bond, and the bond ended up being over $2,000 based upon the amount of his estate. And that was a cost out of pocket. They're not going to get that money back. They have to have the bond. What Mike is getting at actually has to do more with probating estates versus bypassing probate. And a couple of the ways that you can bypass probate are through creating trusts, through creating transfer on death designation affidavits for all of the property that you're able to do that for. Generally, the property that you can create TODs for are bank accounts, checking and savings accounts. Those are accounts that the banks don't generally put the piece of paper in front of you and tell you you should list a beneficiary on here. But it is something you're able to do if you go to your bank and ask them for a TOD for that account. So I do recommend to all of my clients to go to their bank and get the TOD form for those checking and savings accounts that they have. Because that will keep it out of probate, especially if you have a significant amount of money sitting around in a checking account somewhere.
Buy a bond.
Okay.
Sorry.
The other things that you can do TODs for, you could do TODs for real property. So if you have a house, if you have rental property, it's a great idea to do TODs for those. Basically, the process is you fill out the TOD, it gets recorded, and then whoever that you named as a beneficiary, once something happens to you and perhaps your spouse, they go and file what is called a survivorship affidavit with the county recorder's office, and that gets transferred immediately to them. And they don't have to wait for the probate court, they get it immediately. The other pieces of property that you can that you can fill out TODs for are retirement plans. I know that Mike does this with all his clients, so if you're a client of Mike's, then this shouldn't be an issue. The other things you can do, you can actually do TODs for vehicles. That's something that's a little less common, but it does make the process a little bit easier because you don't have to go through probate. Now, in terms of the cost analysis, if you do TODs on all of these pieces of property that you're able to prepare TODs for, the checking accounts, savings accounts, retirement accounts, real property, those do not go through probate, which means that your attorney that helps the executor administer your estate does not get fees on that. So fees in the counties, in Montgomery County and Greene County, are based on a percentage. So there is a different percentage level for each different type of property. So for instance, for real property that gets transferred, the percentage might be somewhere around, let's say, 6%. So the attorney would get 6% of the value of that asset for doing the work to administer that.
So somebody's got a $200,000 home.
Yes.
And they didn't have a TOD, and they didn't have a will, and it goes through probate.
Yes.
They're going to get $12,000 roughly for shuffling paper?
The first thing I will do is, even if they have a will, that doesn't necessarily keep it out of probate. It will still get probated. So I just want to correct that little misstep perhaps. So even if you have a will, it can still get probated. The only way you're going to keep that out of a will is by doing a trust or a TOD. Yes, if it's 6%, I'm not a math person myself, that's why I'm not a tax person, but yes, it's going to be based on the value of that asset. They will have appraisal done on that asset, and then whatever that percentage is, they're going to get a percentage of what that value is for doing that. If you have a transfer on death, then they don't get that percentage. They're not going to get the fee for that. So that's one way, certainly, to keep the attorney's fees down. It will keep the attorney's fees down for all of those assets that you're able to do a TOD for. So if you do it up for the real property, for the retirement accounts, if you have a significant in your retirement accounts, if you have it on TOD, you will not, the attorney will not get a percentage of that, because there's no work for the attorney to do on that.